The cameras flashed, the crowd froze. And just like that, Hollywood had a new obsession.
Oh, absolutely.
I mean, imagine a 17th century French estate. We're talking 1,200 acres right in the heart of Provence.
Right, just stunning.
You've got these sprawling pine forests, ancient olive groves, private lakes, and this incredible 35-room stone chateau.
Yeah, it really is a fairy tale property.
It is. And the place is so legendary, so culturally significant, that Pink Floyd actually recorded parts of their album, The Wall, in a recording studio right there on the grounds.
Which is wild to think about.
Lovely.
Yeah.
Normally a place like this is, a romantic sanctuary. It's the kind of property you buy to grow old in, to just escape the noise of the world.
But today, that exact estate is ground zero for probably the most expensive, vicious business divorce in modern entertainment history.
Welcome to StarScope Report. Join us as we uncover Hollywood drama, music industry shakeups, and viral influencer scandals.
From red carpet surprises to social media controversies, we dive deep into the stories behind the fame.
And today, we are doing a deep dive into a massive headline. Brad Pitt scores another win in long-running fight with Angelina Jolie.
Yeah, this case just keeps evolving.
It really does. We are pulling from a massive stack of sources today to figure out how this fairy tale estate turned into a full-on corporate battlefield.
We've got international news reports, celebrity legal updates from TMZ, and even some high-level corporate analysis from Ehrenberg Goldgen.
Right. Plus, we are looking at California community property rules via divorce.law and some really fascinating legal theory from the Villanova Law Review.
Because the mission here is to look way past the tabloid headlines, right? We want to uncover the brilliant corporate loopholes, the ticking clock of their legal strategy, and the contract theory behind it all.
Exactly. It's an absolute masterclass for anyone who ever signs a business agreement. So let's just get into it.
Let's do it. To really grasp the stakes of this legal war, we have to start with the asset itself. The scale of what they are fighting over is just immense.
So Pitt and Jolie first leased Château Miraval back in 2008, right?
Yes. They were looking for a long-term family property in Europe, a place shielded from the paparazzi, so they moved in with an option to buy.
And then 5 years later, in 2013, they actually exercised that option and bought the estate for $28.4 million.
Which is a huge number, but they didn't just sit on it as a vanity project.
Right, because we see that a lot in Hollywood. A celebrity buys a vineyard, slaps their name on a mediocre bottle of wine, and, just uses it as a tax write-off.
Exactly, but that is not what happened here. They actually partnered with the Perrin family.
The Perrin family.
Yeah, they're these fifth-generation vintners. They are the absolute powerhouse behind Chateau de Beaucastel in the Rhone Valley.
Oh, wow, so they brought in real experts.
They did. By bringing them in to co-venture and launch Miraval Rosé, Pitt and Jolie secured serious institutional winemaking credentials.
So they basically combined Hollywood marketing reach with generational agricultural expertise.
Precisely.
Yeah.
And the results were explosive.
I mean, I remember this. The first vintage of their rosé sold out online in 5 hours.
5 hours? We're an unproven celebrity wine.
It's crazy.
Yeah.
And by 2020, they were pumping out 500,000 bottles annually, distributing to over 80 countries.
Which is why industry estimates push the estate's current valuation to roughly $500 million.
$500 million.
Yeah.
That is a 1,650% appreciation in value from their initial purchase price.
Which brings up the crucial question of how you even structure the ownership of a $500 million asset.
Right. So initially, they split it 60-40. Brad Pitt held 60% through his personal business entity, a company called Mondo Bungo.
And Angelina Jolie held 40% through her entity, which was called Nouvelle.
But then in 2013, the very same year they officially bought the property and got married, there was this pivotal shift, and I am honestly still trying to wrap my head around this.
The €1 sale.
Yes. Pitt sold 10% of his stake to Jolie for a single solitary euro. That restructured the ownership to an even 50-50 split.
Yeah, it sounds crazy on paper.
Okay, let's unpack this. Handing someone 10% of a highly lucrative, appreciating asset for €1. I mean, it's like handing someone the keys to the missile silo for $1.
It really is.
Isn't a 50-50 split the absolute worst idea for decision-making if a relationship goes south? Like, why on earth would his lawyers allow that?
Well, if we look at the context of 2013, this was intended as a romantic gesture. It was made by a couple who truly believed they were building a forever legacy for their children.
Okay, sure, a symbol of equal partnership. But legally,
Legally, it was the activation of a ticking time bomb. The most expensive oversight in modern celebrity estate planning is that Pitt and Jolie did not have a prenuptial agreement outlining the division of this specific asset.
wait, really? No prenup for a massive French estate?
No prenup. So when they filed for divorce in 2016, that 50-50 split meant neither of them had the controlling authority to break a deadlock.
But wait, didn't they have some sort of safeguard in place? Even without a prenup, people don't usually go into business totally blind. There has to be some mechanism to stop one person from just walking away and selling half the company to a total stranger, right?
There was. There was a safeguard built into the corporate structure itself. The estate was officially held by a Luxembourg company called Quimicum.
Okay, quimicum.
And the Articles of Association for Quimicum included a right of first refusal.
Meaning what, exactly?
In plain terms, it meant that if either Mondo Bongo or Nouvelle wanted to sell their shares in the company, they had to offer those shares to the other partner first, or at least get their consent.
Okay, that makes sense. It's a very standard corporate mechanism so you don't suddenly find yourself in a 50-50 business partnership with a total stranger you didn't choose.
Exactly. Which perfectly sets the stage for the trigger event that blew this whole thing wide open.
Oh, this is the part that's just wild. But before we get into the crazy corporate loophole she used to bypass that contract, if you're loving these Hollywood twists, make sure you're subscribed. We've got even crazier stories ahead in this deep dive.
You really don't want to miss this next part.
So, late 2021, Jolie sells her 50% stake for an estimated $60 million,
Right, to Tenuta del Mondo.
which is the wine division of the Stoli Group, controlled by the Russian billionaire Yuri Shefler.
That specific sale is what transformed a messy, prolonged divorce into an all-out corporate war.
I remember reading about this in Variety, just being in total shock. I need you to explain the mechanics here.
Sure.
If I have a contract saying I cannot sell my shares without your permission, and I just go ahead and sell them anyway, I am in breach of contract.
That would be the logical conclusion, yeah.
Right. You sue me, the court reverses the sale, case closed. How did a $60 million transaction just bypass a written right of first refusal?
To understand how she bypassed it, we have to look at how ultra-wealthy individuals structure their assets. According to the Ehrenberg-Goldgen analysis, they almost never own things in their own names.
They use holding companies.
Exactly. A holding company is just a business entity whose entire purpose is to own other assets. People use them for tax shielding, for anonymity, and to silo liability.
So if someone slips and falls at a vineyard, they sue the vineyard's holding company, not the celebrity's personal bank account.
Spot on. So Pitt has Mondo Bongo and Jolie has Nouvelle. Those are the holding companies.
Okay, if I follow.
And the brilliant, frankly ruthless corporate loophole Jolie's legal team utilized relies entirely on those holding companies. Jolie didn't technically sell her shares in the Luxembourg company, Quimicum.
Because the contract strictly forbade selling Quimicum shares.
Right. Instead, she sold 100% of her holding company, Nouvelle LLC, to the Stoli Group.
Oh my God. Here's where it gets really interesting. It's like saying, I'm not selling you the cash inside the safe. I am just selling you the entire safe itself.
That is the perfect analogy. It completely bypasses the lock on the cash.
That is unbelievable.
The transfer restrictions in Quimicum's articles only applied to the direct sale of Quimicum shares. There was no explicit provision preventing Jolie from unilaterally selling the LLC that held those shares.
So the lawyers who drafted the original agreement in Luxembourg just failed to include language covering indirect transfers of control.
Yes. They didn't cover the sale of the parent companies, so Pitt was left without a straightforward breach of contract claim.
Wow. So because the contract was technically incomplete, Pitt couldn't just point to the document and say, hey, you broke the rule.
Nope. The text didn't forbid selling the LLC, even if it clearly undermined the whole point of the agreement.
This is what contract theorists call the incomplete contract dilemma, right?
Exactly. No matter how much you pay your attorneys, they simply cannot predict every single loophole, every creative corporate maneuver, or, every future state of the world.
So Pitt is arguing that the intent of their agreement was clearly that neither could sell their interest in the vineyard to an outsider without consent.
But Jolie's team found the technical gap in the text, and they drove a $60 million truck right through it.
That is just wild. And because of that loophole, Pitt was forced to sue on much harder to prove subjective grounds.
Right. We're talking claims of tortious interference, breach of implied contract, and breach of the covenant of good faith and fair dealing.
He has to prove her intent was malicious, rather than just pointing to a broken rule.
And that is a much steeper hill to climb in court, which is why this litigation has become so sprawling.
Which brings us right up to the current legal war. And this brings us back to our headline: Pitt scoring another win in this massive fight. But later in the episode, we'll talk about the shocking twist nobody saw coming regarding the witnesses in this trial.
It is a really dark turn, honestly.
But first, stay tuned and hit that subscribe button so you don't miss what's coming next. Let's look at the sheer scale of the lawsuit now.
It's massive. Pitt initially sued for $35 million in damages, claiming this sale to Stoli was a hostile takeover.
But with all the claims and counterclaims over the last few years, the broader dispute is now valued at $164 million.
Yeah, it ballooned quickly. Jolie countersued through her Nouvelle entity, claiming Pitt was hijacking the business, freezing them out of decisions, and wasting corporate assets.
She even included a line item claiming he wasted $1 million on swimming pool renovations.
Setting the pool renovations aside, we really need to look at the underlying legal environment governing their relationship.
Okay, let's do it.
This case is actually becoming a landmark precedent for regular people going through a business divorce, particularly regarding how long your obligations to an ex-partner actually last.
See, that is something that genuinely confuses me about this timeline.
How so?
Well, Pitt and Jolie were declared legally single way back in 2019. Their divorce was what courts call bifurcated.
Right, bifurcate.
So if they were legally single in 2019 and the sale to Stoli happened in 2021, why does she need to care about his feelings or get his consent at all? Shouldn't she be entirely free to do whatever she wants with her half of the property?
You would definitely think so, but a bifurcated divorce means the court officially ends the marriage status so the parties can move on, but it leaves the complex division of their shared assets to be sorted out later.
Ah, okay.
According to divorce.law, this is where California Family Code Section 1100 comes into play.
And what does that say?
Under California law, fiduciary duties to a spouse survive a bifurcated divorce until all community assets are fully and legally divided.
Okay, let's define fiduciary duty for a second, because that sounds like heavy legal jargon.
It does, yeah.
It basically means you are legally obligated to act in the other person's best financial interest. Right. Almost like you are managing their retirement fund. You can't just make a reckless trade because you're mad at them.
That's a great way to think about it. California law requires ex-spouses to manage community assets with the highest duty of good faith toward each other until the ink is dry on the final property division.
So Pitt's argument is that selling her half of their jointly owned, highly personal business to a controversial third party, in secret, violates that surviving fiduciary duty.
Yes, he is arguing she breached her duty of good faith regardless of whether the LLC loophole technically allowed the sale.
And speaking of that controversial third party, we have to look impartially at the narratives surrounding the Stoli Group and Yuri Shefler.
We do, because both sides are spinning this very differently in the court of public opinion.
Right, and just to be clear for our listeners, we are entirely neutral here, just reporting what the sources and court documents are stating.
Exactly.
So Pitt's team claims that Shefler was chosen specifically to hurt him. They point out that Pitt would never want to partner with Stoli, citing international boycotts against the company related to Russia's invasion of Ukraine and anti-LGBTQ laws.
They are essentially saying she weaponized the buyer against him to force him out of his own sanctuary.
But Jolie's team forcefully rejects that narrative.
Completely. They claim she chose the Stoli Group purely for business reasons.
Right, because Stoli is an excellent world-class distribution partner with a massive global footprint.
And her team argues that partnership could actually help grow the Miraval brand, which ultimately benefits their children who stand to inherit the estate.
So her camp claims that the real issue is just Pitt's ego and obsession with control, and that he simply refused to work with Stoli because she was the one who chose them.
It's a classic he said, she said, but played out on a $500 million stage.
However, looking at the actual court dockets from recent months, and this is where the title of our deep dive comes in, Pitt has been scoring some major procedural victories.
He really has. And these pretrial discovery wins might sound dry, but they are often where cases are quietly won or lost before a jury ever enters the room.
Let's break a few of those down. First, a judge ordered Jolie to hand over 8 years of non-disclosure agreements, or NDAs, that she had signed with third parties, plus 22 previously withheld private documents.
Yeah, and Jolie's team fought this hard, claiming privilege, but the judge completely rejected that.
Why are NDAs so valuable in a case about selling a wine company?
Because they show a pattern of behavior and intent. Pitt's team is likely looking for evidence of hypocrisy or strategic maneuvering.
Ah, so if they can show she routinely used NDAs to silence people in her own life, it undermines certain arguments she might make about transparency or standard business practices.
Exactly. Gaining access to 8 years of private contracts gives Pitt's lawyers a massive trove of ammunition to cross-examine her credibility.
And then there's the billionaire oligarch trying to avoid court altogether.
Right, Yuri Shefler.
An appeals court just ruled that Shefler himself and a Stoli executive named Alexei Olenek cannot avoid testifying. Shefler tried to claim he had very little direct involvement in his company buying Jolie's stake.
So he felt he shouldn't have to sit for a deposition in California.
But the judge's response to that attempt was brutal.
It really was. The court stated that it, quote, defies credulity that a sophisticated billionaire would risk almost $40 million on a transaction about which he knew nothing and had no involvement.
It's just a polite, judicial way of calling his bluff.
It really is. By compelling Shefler to sit in a room and answer questions under oath, Pitt's team is trying to prove that Shefler actively helped structure that clever LLC loophole.
To intentionally bypass Pitt's rights, they want to show it was a coordinated backdoor deal.
But this raises a massive red flag about contracts in general.
How so?
Well, if you sign a piece of paper in 2008, how can it possibly account for a billionaire buyer, a global conflict, and a bitter divorce in 2021?
That is a great point.
There's this legal concept explored in recent property rights literature, specifically in the Villanova Law Review, called stale preferential rights.
Okay, stale preferential rights. What happens when a contract essentially ages out of its usefulness?
When parties sign an agreement, like the Miraval right of first refusal, it makes perfect sense in the context of that specific moment.
Right, because in 2008, they were a happy couple trying to protect their family home.
Exactly. But when a contract lasts for 10, 15, or 20 years, that original context entirely vanishes.
The environment changes. The relationship changes from romantic to hostile. And, the value of the asset completely changes from a $28 million property to a $500 million global enterprise.
And this leaves courts in a terrible bind. Do they stick strictly to the letter of the law?
Which in this case means allowing the clever LLC loophole because the text drafted in Luxembourg didn't explicitly forbid it.
Right. Or do they enforce a subjective duty of good faith and look at the intent of the original partners, effectively rewriting the contract to fix the gap?
The older the contract, the harder it is to prove what the original intent even was.
Which makes time itself a central character in this story.
And it brings us to the most dramatic current development in the case, the race against death.
It sounds theatrical, but in the realm of high-stakes civil litigation, it is a very grim, tactical reality.
The trial is currently set for February 2027, but Jolie's team is trying to delay it by 9 months, pushing it to November 2027.
And Pitt is fighting this delay tooth and nail for a very specific strategic reason.
The witnesses who actually know what happened, the people who were in the room when these deals were structured, are dying or getting too sick to testify.
This is the literal weaponization of time.
Pitt's legal filings point out that Terry Bird, who was Jolie's longtime business manager and a central figure in negotiating the Stoli sale, has already died.
Furthermore, Laurent Schumer, the Luxembourg-based attorney who actually handled the transaction and presumably knows exactly why the LLC loophole was used, is described in court documents as being likely too ill to testify.
So every single month this trial gets delayed, Pitt's evidentiary record literally weakens.
This isn't just about who gets to drink wine on the terrace of a French chateau. This is a brutal game of attrition.
In civil litigation, stalling is a highly effective strategy, isn't it?
Absolutely. If your opponent's key witnesses disappear, their ability to prove that implied intent or that breach of good faith evaporates with them.
You are left with nothing but the strict text of an incomplete contract. It is just wild to think about. A romantic 17th century estate where rock legends' recorded music has turned into a ticking clock of witness mortality and corporate loopholes.
The stakes are incredibly high, not just for the two of them, but for the precedent this entire saga sets for corporate law.
So what does this all mean for you, the listener? Well, whether you are buying a massive French estate with a Hollywood A-lister, or you're just starting a small local business with a friend, The exact wording of your transfer restrictions really matters.
And the absence of a prenuptial agreement matters.
Château Miraval is going to outlast Brad Pitt and Angelina Jolie. I mean, it's been there for 400 years. It's not going anywhere.
But the legal precedents being set right now in Los Angeles courtrooms will rewrite how business divorces and community property disputes are handled for decades to come.
As business contracts become increasingly complex, and as wealth is stored in these intricate webs of holding companies and LLCs, will courts eventually have to abandon the strict letter of the law entirely?
It's a thought that really lingers.
If a loophole as clever as selling a holding company instead of the shares inside it can ultimately be struck down by a judge citing a vague duty of good faith, is any written contract truly ironclad anymore?
Or are we all, at the end of the day, just at the mercy of a judge's interpretation of what we intended to do?
The ink on the paper might be dry, but as we've seen with Miraval, the X-ray machine is broken and the waters are incredibly murky. Next time you listen to Pink Floyd's The Wall, just remember the $164 million war currently raging inside those very stone walls.
It definitely changes how you look at a bottle of rosé.
It really does. You've been listening to StarScope Report, where Jordan and Jamie uncover the stories shaping Hollywood, music, and pop culture. Thanks for tuning in, and don't forget to subscribe for more stories that keep the stars shining.